Hello everyone, my name is Kristin Campbell-Wilson. I am the Deputy Secretary General of the Arbitration Institute of the Stockholm Chamber of Commerce. I am currently doing this seminar from home, which is also where I suspect that many of you tuning in are also at currently. This is unprecedented and challenging times, and little did we know 2 months ago, or less than 2 months ago, that all the events and conferences that were scheduled in our individual calendars would all be cancelled and travel restrictions would be in force. This particular seminar has traveled the world previously from Tokyo to Almaty in Kazakhstan, to St. Petersburg, to London, and there were more events scheduled throughout the spring. Of course, these have now been cancelled, and considering that a large part of our community have a need to meet in events and different seminars and conferences in order to discuss and exchange ideas and different points of view for the better of the community and arbitration at large, the SCC decided that we were going to try and keep the conversation going, and then announced a series of online seminars that you can take part in should you wish. More information on this you can find on our website. It's also might be a good idea to sign up for our newsletter so that you don't miss out on any information, and that you can also do via our website. It's also possible to add us to your LinkedIn, and that way find out more of the seminars that we will continuously add to the schedule of seminars already in place. Before I move on to today's topic, I'd just like to go through some housekeeping matters, and that is that you have all been muted by my colleague Lise, who's joined us as well. We have, if nothing else, if Lise could do that for everyone, because it will be easier to give the seminar if you're all on mute. However, we do invite you to pose questions, which you can do through the chat function, which should appear on your screen. Lise, my colleague, will help me keep track of the questions that you have and allow for time at the end of the seminar for you to pose that question, or if you write your question down in the chat message function, then she will ask it on your behalf. One more important aspect is that this particular seminar is being recorded. So if anyone is uncomfortable with that, you need to keep that in mind should you want to ask any questions, or if you would prefer not to take part in the seminar at all. But that's up to you, as long as you are aware that we are recording the seminar. So moving on to the actual presentation, I have, let's see, here we are. So on today's agenda, the seminar is divided up into two parts. The reason being that we have about 140 people who have signed up for the seminar, and the vast majority of them seem to be unfamiliar with the SCC. So the first part will be a general introduction to the SCC and the role that we play in international arbitration. The second part will be an introduction to the SCC platform, whereby I will go through the different considerations that we made in developing this particular platform, and then also give you a brief demonstration of the platform itself. So, and before I leave you today, I also have an announcement of a new initiative that the SCC is making public today. So to keep you on your toes, I won't give anything away now, but rather announce this at the end of the seminar before we say our goodbyes. So, who is the SCC? Well, the SCC, the Arbitration Institute of the SCC, the Stockholm Chamber of Commerce, was established in 1917. And since then, more than 100 years ago, we've grown into one of the leading forums for international arbitration as one of the leading arbitration institutions and dealing with dispute resolution. So, and how did that happen? Well, we had three major events taking place primarily throughout the 70s and 80s, when, for instance, the first event happening in 1977 was when the US and the USSR during the Cold War needed a place for resolving trade disputes between the two blocs. And the choice fell on the SCC, Stockholm in Sweden. That was the starting point. In 1984, China followed suit by entering into a cooperation agreement between its CCPIT, which is the China Council for the Promotion of International Trade, and the Stockholm Chamber of Commerce, whereby China acknowledged the SCC as the only then foreign institution to administer Chinese-related international disputes. In 1993, another major event happened when the SCC registered its first investor-state dispute. Since then, the SCC has registered more than 110 cases, investor-state disputes. The majority of those have been under the SCC arbitration rules, and that in itself makes us a leading institution and second only to ICSID to administer these kinds of disputes. Today, we administer approximately 150 to 200 cases per year. We have quite a vast scope, geographical scope, where we see approximately 40 jurisdictions or nationalities represented in our statistics every year. I can show you a brief, well, I'll get back to that a bit later, actually. We have still, we see a lot of our cases having the east-west characteristic, and a large part of our caseload also relates to the energy sector, be it gas or oil related or renewable energy. And as I mentioned, investment arbitration is also one of the characteristics of the caseload at the SCC. We administer cases under a number of different rules. The two main sets of rules are the arbitration rules and the rules for expedited arbitration. In 2010, we included provisions on the appointment of an emergency arbitrator, which was at the time a novelty in arbitration, but has since been included to most institutional rules at the main arbitral institutions, international institutions. We also act as appointing authority in ad hoc arbitrations, and including UNCITRAL, but we also have procedures in place to administer UNCITRAL arbitrations. And we do mediations as well. So to sum up briefly the key features of SCC arbitration and what we stand for, as I mentioned, it is an internationally recognized institution where we see approximately 40 countries represented in our caseload every year. This particular graph displays last year's registered arbitrations. And as you can see, following Sweden, Russia was had the most, was highly represented, or was the nationality represented in our case, so that had the most cases, followed by Germany, the USA, and United Kingdom. Not far behind, you can see we have our neighboring countries of Finland, Denmark, Norway, and then Italy, Ukraine, and China. And as you can see, most of our parties come from the Northern Hemisphere. This is a picture that we see recurring every year. So it's pretty much is a good it depicts where our parties come from on an annual basis. The SCC is also an impartial and independent institution. The Stockholm Chamber of Commerce is a private entity. It's a member organization for businesses in the Stockholm region. And this is in contrast to a lot of other institutions or arbitral institutions, which are part of government authorities or otherwise funded or financially supported by the state. The Arbitration Institute of the Chamber is a separate department and an independent department, and it's organized in a secretariat that handles all the daily operations and the case administration. And it has an SCC independent from the Chamber SCC board who decides on procedural issues under our rules. In addition to being acknowledged as a experienced and neutral venue for international disputes, the SCC has also gained recognition for being an innovative institution with a large focus on time and cost efficiency. And I will just give you a brief summary of the different innovations, let's say, that the SCC have come up with over the past 2 decades. They have been both of a procedural nature with additions to our procedural rules, but also in the way we administer cases with a large focus on digitalization and technology. The first main initiative was launched in 2012 with the Swedish Arbitration Portal, which is a database, let's say, where you can find English translations of Swedish court judgments and decisions related to arbitration issues. And this was in order to make more easily available Swedish case law, as many of our international cases have their legal seat in Stockholm or elsewhere in Sweden, but primarily in Stockholm. In 2013, we left the paper trail and went digital in terms of the case management. So since then, all our cases are administered online, or not online, but digitally, which means that it's been easy for the SCC under our current circumstances to reorganize ourselves and work from home. Our latest initiative is what we're supposed to talk about here today, and that's the SCC Platform. And the SCC Platform is a secure case management platform for communication and file sharing among the SCC, so the institution, the arbitrators, and the parties. And the reason why we wanted to do this is, well, twofold, I'd say. The first one being that the community, we had been listening for years that the demand for something like this had increased over the past years. And it was for a long time on the SCC's to-do lists, let's say. It was also an opportunity for us to make yet more efficient, both in terms of cost and time, for SCC arbitrations. So in August of 2018, myself and my colleague Lisa Alm, who's here with me today, sat down and started pinning down what is it that we want to achieve and what do we need in order to achieve that. And what we came up with was the following wish list. We knew that, of course, for this to fly, it had to be a platform that was relevant, that it included all the features that you might want to have or need in an arbitration to run it smoothly and efficiently. It, of course, needed to be user-friendly. The legal industry is not known to be a fast-moving industry in terms of technological developments, and we knew we needed to win over also the less tech-savvy arbitrators and councils if we wanted to make this shift and go digital. So those were two main points that we were trying to achieve in developing this. It, of course, needed to be cyber secure. Arbitrations contain a vast number of sensitive material, and that was, of course, a very important aspect of coming up with this platform. There are other aspects that I will address in a little bit as well. The SCC is also it was very important for the SCC to have this service included in the administrative fee. We are very time and cost focused, and we didn't want this necessarily to be a point of discussion for the parties of whether or not to pay for this as an extra service. So we wanted this to be included in the administrative fee. When it comes to security in particular, there are several aspects. You have the human factor that I touched upon a little bit. You need to be able to cater for both the tech-savvy lawyers out there and also the less tech-savvy ones. It needs to be a product or a platform that that minimizes human errors or the risk of human errors. It should not be easy to make mistakes on this particular platform. The technical aspects of the platform, we quite early on identified our supplier HiQ, which has since been acquired by Thomson Reuters, as the one we wanted to work with. HiQ is also known to many legal practitioners out there. They are the provider of similar M&A platforms and such to more than 250 law firms around the world. We did engage external security consultants in order to perform pen tests or penetration tests, essentially trying to hack the system. And this is something that we will continuously do on a regular basis to ensure that the technical security remains intact. As far as physical security, the servers where the data is stored are located in Germany. There are also backup facilities also stored in Germany. If you're interested in knowing more about the physical security surrounding the servers and how this is being addressed, you can find out more on our website on these particular technical details. But it's basically surrounded by lots of different Mission Impossible security measures. As far as the legal aspects are concerned, they come in various different forms. So one of which was, of course, the jurisdiction of the storage location, which is Germany, and other legal requirements between the SCC and HiQ, as well as the SCC and our users that have all been addressed. So how does the use of the platform work? Well, when we receive a request for arbitration, we will provide a site on the SCC platform and invite the participants to the arbitration to register on the platform and create their profile. That is the first time you log in, you need to create a profile on the platform. This is the profile that you will have on the platform for all of the cases that end up on the platform. The use itself is pretty much well, the use of the platform is not mandatory for the arbitrators and the parties. However, it is necessary for the arbitrators and at least one individual, one representative of each party to the proceedings to log in and register in order to be able to receive communications from the SCC. So with the launch of the SCC platform, the SCC will only communicate with the arbitrators and the parties via the SCC platform. And for that reason, it is necessary to interact with the platform somewhat. But beyond that, it is up to the arbitrators and the parties to decide if they want to manage the case on the platform. It is also indeed included. The majority, access and use of the platform is included in the administrative fee, and also storage of data is in the majority of cases included in the administrative fee. However, we realized that we needed to have some sort of limit in terms of data storage to have a little bit of room, as we do see really large and document heavy cases at the SCC. So we needed to have a little bit of event in terms of those particular cases, but the vast majority of SCC arbitrations will be able to use the SCC platform for free. Right. This is a sneak peek of the SCC platform, and I am about to leave the presentation in order to give you a bit of a demonstration of the actual a mock site, let's say. But before I do that, I'd like to inquire into whether or not there are any questions so far. No?
Yes, sorry,
yes?
No, yes, there is. Can parties and tribunals use the SCC platform for communication between themselves? And I think you may have touched on it, but please do elaborate.
Yeah, they can communicate amongst themselves. However, the SCC platform does not eliminate the use of email completely. So there are limits to how you communicate on the platform. I will demonstrate it slightly, but if you see here on this particular slide, you have something called tribunal notices. This is a sort of a blog post function whereby the tribunal can notify parties of certain practical aspects. For instance, discussion on hearing dates or dates for, case management meeting or change of venue for a hearing or what have you. This function is for the arbitration tribunal to use. However, parties can respond to those posts or those notices that are added by the tribunal.
We have a couple more questions. One is, can somebody register to try out the platform, to test it?
A very good question. For anyone who is interested in that, I suggest that you contact either me or Lisa via email. Our contact details are found on our website, and that can be discussed further.
And then in terms of registering with the platform, one can create a profile once you become involved in the SCC case, but not in advance, correct?
Sorry, could you repeat that, Lisa?
I can actually say that it is correct. You register a profile on the platform once you have a case with the SCC, not beforehand. So you cannot have a profile on the platform until you have a case.
Yeah.
Next question is, sorry, Kristin, if you want to.
No, that's correct. So basically, you will be invited to join a site on the platform, and when that happens is basically when we receive a request for arbitration, we will invite claimants' counsel to access the site on the platform. We will invite respondents' counsel to the platform once we serve the, at the same time we serve the request for arbitration. Arbitrators, however, will be invited at the point of referral of the case to the arbitrators.
And another question is there a size limit for the submissions and exhibits per party?
There is no size limits to this particular for any party. However, as I mentioned, the storage, the data of storage is included in the administrative fee up to a certain limit, and so cases have data storage combined for the entire arbitration up to 10 gigabytes. Included in the administrative fee. Should you go beyond that or go beyond the number of user accounts that you are allowed, each party is allowed 5 user accounts, and also, of course, the arbitrators. That is all included in the administrative fee. But should you go beyond that, the SSC will charge a small fee with 6 months intervals.
And to add to that, I also want to clarify that in terms of individual submissions, there are no size limits. So the individual submissions can be essentially indefinitely large. We've tested this out and they can be ridiculously large. We do have a number more questions, but I'm wondering if maybe I should save some for the end, just to allow you to continue on your schedule.
Yeah. So this is basically a mock case that we have put on the platform in order to make these demonstrations. This particular case is between Candy LLP and Tooth Fairy AB. And this is the landing page for any site. And what you will see at the top bar here, you will have the case number and the parties, the name of the parties. You will have a general information page, which is the one that is displayed currently. You will have a files tab, calendar, participants, and tribunal notices, as I mentioned earlier. So on the general information page, you will have an overview of the case at hand, which division at the SCC is administering this particular arbitration, anything that is coming up in the calendar that is related to the arbitration. This particular calendar can be synced to your home calendar, for instance, in Outlook, which will be, of course, very efficient for everyone involved. The latest or most recently uploaded files will be displayed, so you can instantly see, okay, so such and such document was just uploaded on the site, and then you have any tribunal notices that have been posted in this case. Below you will have an overview of everyone involved. So anyone at the SCC, a legal counsel and a case administrator, who sits on the arbitral tribunal, and who the representatives of the parties are. And this information that is being displayed here is, oops, oh no, okay. Here we go. Always very exciting when unexpected things happen. Let me see if I can try this again. Yes. So, for instance, the information on Natalia Petrick is the information that she has put in herself on her platform profile. So, contact details, all of this is the participants' job, let's say, to add to the platform. There is when you do register on the platform, there is also a section that is to do with more that has more of a social aspect to it, like your hobbies and things. That is not necessary to add to your profile if you don't feel the need to, if you don't feel like it. We've had some interesting questions coming from arbitrators whether or not they should write down that they are big fans of fly fishing, for instance. That is not necessary. So this is a good overview of who the participants in this particular arbitration are. Below you will have access or link to the SCC Platform guidelines. A lot of the information in the guidelines is also displayed here on the general information page. There is short or brief instructions on how the different functions are to be used, how they work, how you use them, as well as information about folder structures. I will come back to that in a little bit. As well as how to deal with certain things like how-to guides, as you can see here. So, but scrolling back up, the landing page will give you a nice overview of what is the latest or what is to come in this particular case. However, the tab that will probably be the most used by everyone involved is the Files tab. And here you will see on to the left a number of different folders. There is a folder called the SCC, and this is to allow for communication to the SCC and where communication from the SCC will be uploaded. When it comes to the other main folders here, you see option A, option B, option C. These are folder structures of which the participants will be asked to choose one of them to use during the arbitration. This is something that the parties will need to inform the SCC of at the time of early on in the arbitration, and when it submits, the arbitrator submits a timetable, for instance, for the arbitration. That is the point at which we would like to know which folder structure the parties want to use. The basic one is basically just folders that are refer to who is submitting the information, the claimant, respondent, or arbitral tribunal. Then we have two other options, the thematical order and the chronological order. And just to quickly show you how that it looks. So where you have the chronological order, you will have submissions 1, claimant submission 1, respondent submission 1, etc. You will have subfolders for exhibits, legal exhibits, witness statements, and the like. As you can see here, the first folder, it says submissions in Word format, not visible to the respondent. This is one of the few exceptions to transparency on the platform. Overall, everything that you upload onto the arbitration or the allocated site is visible to all of the other participants to this particular arbitration. However, we realize that parties often send Word Word versions of their submissions for ease of use or to make it convenient for the arbitral tribunal, which is why we've added such a folder to be used only for submissions in Word format. There is a similar folder that's only visible to the SCC and the arbitrators, and that is a folder to be able to communicate practical information such as bank details and that sort of thing. But otherwise, the main rule is that everything is available to everyone to read, download and view. We work with user rights to these different folders. So we have put in place safeguards, let's say, or working with user rights to ensure that you don't upload your submission in someone else's folder, for instance. So if you are an arbitrator, which is what I am currently logged in as in this particular mock site, I can only upload information to those folders that I have access to or rights to upload to, which is, for instance, here in, let's see if we can use this one. Procedural orders, let's say. So as an arbitrator, oh, and I should show you if I, the way you can see whether you have rights to upload something or not is that you will see whether or not you have an upload button up here above the folder structure. So going back to procedural orders, and as an arbitrator, I have the button upload. So I would like to demonstrate how to upload files to this particular case. I can choose to browse my computer, or I can also drag and drop. So I have chosen a few, prepared a few documents to upload to this particular case here today. As you can see, you're able to upload several files in one go, so you don't have to do it one by one. And when you upload, you press this button here, Add. So here you have 4 documents that I've uploaded to procedural orders. Going back to the general information site or view, you should be able to see these documents here coming up, and here they are, the most recently uploaded files. The Tooth Fairy's Evil Twin, for instance. If you press that, you will have a preview of the documents, and this works for all different kinds of, or most kinds of formats. So you have the ability to preview pictures, PDFs, Word documents, and Excel, which is very handy. I'd also like to demonstrate how you search, how the search function works when it comes to files. There are different views, how you can index them. You can also make favorites. These are individual settings that you amend to your particular profile or your or your individual profile. So and you can therefore also sort them. And this is not viewable to anyone else in the arbitration. This is only for you. So, for instance, these two documents have been marked as favorite documents. But going back to the index and the search function, you can search both the title and the content. Make sure though that if you have a PDF, it needs to be readable to be able to search in the PDF. So let's search for candy, for instance. There should be, I need to press on that, I think. Yes, here we have seven different files containing the word candy. And for instance, let's pick this one. Why is candy good for you? You can also search within that document to find out where in the document you find candy. So search candy. And here you have 15 results found, and where you can skip and hop between the different words where you find candy appear in the document. Any questions so far?
Yes, we have actually quite a lot of questions.
Okay.
So I've tried to cluster them a little bit. There's a couple of questions that are relating to whether or not this can be used for online hearings.
As it is, the platform does not contain a feature, a video conference feature, unfortunately. So this is only to do with the filing and other communication. As of now, it does not contain any video conferencing facility or feature.
Another question is whether or not it is mandatory to use this.
It is indeed not mandatory. We, of course, encourage the use of the platform in the arbitration. It is a tool to make it more efficient and convenient for the parties and the arbitrators to have everything in one place. And this is a means to keep sort of an official record of the case. This is once you submit something in this particular, in one of your folders, that is a submission to the tribunal or the SCC and an official document in the arbitration, let's say. We encourage the use of the platform, of course, because we think it will be to the benefit of everyone involved, but it is not mandatory per se. But as I mentioned earlier, some interaction with the platform is necessary on the part of the arbitrators and at least one representative of each party in order to receive communications from the SCC.
And to some extent, I suppose it becomes a follow-up to this one, but if there are additional costs based on reaching the size limit, how are they allocated between the parties?
This is something that will be charged as a cost on the part of the SCC. So the SCC will charge the arbitration and draw on the advance on cost at the end of the arbitration when we settle the accounts. So that will be considered. So practically, it will be in essence paid 50-50 by the parties, or it will be drawn from the advance on cost, which is usually paid 50-50 by the claimant and the respondent.
Do we in practice see the tribunal members and parties relying on the platform in full, or do we see them downloading copies?
I think that we are very, we're very happy to see that that the platform has been so well received. and we find arbitrators who are using the platform in ways that we had not necessarily anticipated very efficiently. I am sure there are arbitrators who download everything to their personal computer and so forth. So far, we've had one individual who has point blank refused to use the platform, and with in that arbitration, the SCC will of course accommodate the need to remain in the less cybersecure arena of reverting to email. But otherwise, we have very positive feedback from our users.
We then have two questions on legality as well, in terms of one is GDPR, and the other one is what happens if there is a cyber attack in terms of liability. So the first one is, how does GDPR come into this and how does it affect it? And the second one then is, what happens to liability in a cyber attack? Yeah.
So the GDPR comes into this, of course. The SCC falls under the jurisdiction of EU law and also the GDPR. Servers are located in Germany, for instance. So I think that regardless of where you are in the world, GDPR will stretch to an SCC arbitration. However, we work with the SCC privacy policy, whereby we inform parties where how we use the information and so forth. All of that is included in the terms of conditions that we need to, that every participant in the arbitration will need to sign up for and agree to in order to use the platform. If the individual who asked this particular question wants to have a more in-depth answer to any particular aspect of the GDPR, I'm welcome to address that either here, or if her or he would like to send me an email.
And the second aspect of that, liability on cybersecurity, what happens if we get hacked?
I have to say that I think that you're probably better to answer that question, Lisa. But also that question can be asked if the person would like to send an email to me, as I don't remember every single part of the agreement between us and our supplier.
There's a general answer to that to some extent as well, and that is that we are obviously liable for our handling of the cases, whether it's on the platform or the other aspects of our administration of a case. So our liability when we handle cases are covered by the SCC rules, where it addresses what happens and the level thresholds in terms of liability and caps of liability and so forth. This flows under that as well. So from a pure contractual and legal aspect, that's where we need to go for the answer. For the technical aspect, as Kristin mentioned before, we take a lot of actions to ensure that this is a very secure platform. That obviously does not mean that it's unhackable, because no such thing as an unhackable platform, but it is very robust and it is very secure. So hopefully with those two aspects, we partially at least answer that question. I have then a couple of feature and practical questions, and one is, does the platform convert all the PDF to readable format? And if not, does it signal if it's not readable? So this is OCR, does it OCR the documents?
I believe that's a negative answer to that. Yeah, it does not. So you need to make sure that the document you upload is indeed OCR readable.
And how long does the platform stay open after a case has closed?
So another aspect of the platform, which we think will be appealing to arbitrators in particular, that is that we offer archiving service of the case file up to a year after the termination of the arbitration. This is in line with our expectations of arbitrators in SCC proceedings to keep a file a complete file of the arbitration up to a year after the termination of the arbitration. So this is an easy way for the arbitrator to meet that requirement.
I'm gonna quickly do the last couple ones, so I leave you with enough time for your exciting news. Are the guidelines available online? It's a short answer to that one. They are not. And correct. Is it possible to create a chronological flow and chart of the documents that are uploaded to be able to analyze who did what and when?
Ooh, who did what and when? Lisa, do you want to? Yeah, yes. Do you want to take that one? I know you're the expert on that one.
It is entirely possible. So what you can sort all the documents in chronological order through clicking the index. If you go to Files, Kristin, and you click Index, you get them all in chronological order. You can only, in terms of who does what when, you can only really upload, which means that the date and the name that you see there, that's the only amendment that can happen to a document. So if you press on Recent up to the left there, Kristin.
Recent.
Left.
Oh,
your
left.
Other left.
Recent.
That
there
one.
We are.
Yes.
Yes.
That will show you all the documents in the data room, and you can sort them by name, by size, by author, or by last modified, i.e. last updated. And then you can also download an entire index of it. So yes, you can sort them in this way.
Thank you.
And we do have more questions dropping in, but I thought I'd leave them maybe to the end.
Yes.
We'll circle back to any more questions.
Yes, thank you very much, Lisa. So now I'd like to share something else, and an interesting, I don't know, it's not, I'll do that. Stänga alla flikar.
While you do this, Kristin, I can take a couple of short ones while you just change your presentation. One is print screen traceable, and unfortunately it is not, because we can't see if you take a print screen. What is relevant to understand here, though, is that only people who have access to the documents are able to do a print screen, and they are also able to download. So actually doing a print screen for them would be it's a worse option than just downloading. So it's not traceable, but it's not an issue.
Yeah. So now to my very interesting announcement, which is also in response to the current situation we are all finding ourselves in. Once the outbreak of the COVID-19 got more and more intense and spread across the globe, the SCC was approached by arbitrators and parties and wondering what to do now and what's next, and how do we go about this, particularly in response to or in relation to hearings and meetings and so on. However, we also picked up on the need for something like the SCC platform in ad hoc arbitrations, where you don't have this particular support, and where you have now an urging need to manage the proceedings online to a much bigger extent. So I am happy to announce that the SCC, together with Thomson Reuters, have come together to make a version of the SCC platform available to ad hoc arbitrations globally. This is something that we'll be able to offer to ad hoc arbitrations from May, or sometime in May. And this is our way of making it more easy for arbitrators and parties who are finding themselves in challenging circumstances and where they need to put more focus and more of the proceedings online. So we're very happy to be able to announce this today. And if you're interested in knowing more, you can check it out on our website to find out more of how it works and what it could do for you in an ad hoc arbitration. So with that, I am ready for more
Kristin,
questions. Yes.
Did you, and maybe I just missed it, did you mention what it costs?
Oh, sorry. No, it's for free. Sorry. That is a very important feature. So the use of the ad hoc platform will be free of charge for any ad hoc arbitration that registers on the platform by the 31st of December this year. So this is a way of helping out during the COVID-19 crisis, and any arbitration, ad hoc arbitration that is interested in this will be able to carry out the entire arbitration free of charge. Any more questions?
So I'm trying to look through what we have. There's a question in relation to I believe it's in relation to ad hoc, whether it will be subject to the same liability cap, etc., in the SCC rules. I should clarify myself in terms of liability in the SCC rules. There isn't a cap. There is the thresholds. You can find them online, and you can see the exact wording in there. It's fairly short and sweet. We are still working on finalizing what the ad hoc platform will look like, and the terms and conditions is part of what we are trying to what we're putting in place here.
Any more questions?
There's a question that I think we may have answered. Can you show how the joint list of all submissions in a chronological order for claimant and respondent, what that looks like? And I should say that that's essentially the same as we did towards the end there, where you look at recent, you get all the documents that have been sent, and then you can choose to sort them by name, and then you get them, usually clustered them by party, or you sort them by in chronological order. And I'm trying to see if I have missed a question, feel free to post it again. I might have. Otherwise, I think there is a question whether it's possible to download documents directly from Office and Google and so forth, i.e. do you have to populate it via email? And another question there is also, can you use e-signatures on the SCC platform?
These are technical questions that I'm afraid not the right person to answer.
I am happy to.
Yes, thank you, Lisa.
So in terms of uploading it, yes, you don't have to upload via email. You can upload from drag and drop, or you can upload from wherever you keep your documents. So that you can do from wherever you have them. In terms of e-signature, there's no specific support for e-signature, built in. So if you need to have something that is electronically signed, you just upload a virtual copy of it, but we don't have a specific function for it. And let's see, there's a follow-up on whether you have one profile per party or one profile per person accessing the platform. And you have one per person. So that also means that if you have several cases, if you're counsel, for instance, in several ongoing SCC cases, you're going to be able to, you have one profile and you're going to be able to log in to all your different cases using that same profile.
That is correct.
Is this correct? The parties have access to view all the folders of the other party. Do you want to take that one?
Sorry, once more, Lisa.
Is it correct that the parties have access to view all the folders of the other party?
Yes, that is correct. With the couple of exceptions, as I mentioned during the presentation. So, for instance, each party will have a folder not visible to the other side, where you can communicate word versions of your submissions to the arbitrators.
There's also a question on whether there's a protocol on how to name the files. And this is tying on to what we discussed before on how you can sort the documents, because if you do name the documents in a specific way, then you're going to be able to sort them better. So, for instance, if we will always name any document coming from the SCC with the SCC in the beginning as a prefix, and you will have the classic prefix of R for respondent and C for claimant and so forth. So we give fairly general instructions that you should think this through to simplify for sorting, but we don't have a specific for each type of document. Rather that you should stick to it and use prefixes because it simplifies life. Yeah. That's correct. Also there's one more question on ad hoc platform offering. Are the data storage limits, and are the possibility to increase those limits for a fee?
Yes, as I mentioned earlier, so the vast majority of SCC arbitrations, this data storage will be included in the administrative fee. We allow for 10 gigabytes of data storage in the administrative fee. However, would you go above that, the SCC will charge a small fee for every 6 months of the remaining part of the arbitration.
I should clarify as well that to begin with, there's no cases that are touching upon that today. So it is really both the intention and so to date the fact that nobody has hit those limits. When it comes to ad hoc, we are not planning on having any storage or user limits, but obviously there will be some sort of, if it goes into the absurd, we will look at it, but there is no limit from the outset here. Yeah. And I'm trying to see if I have missed anything. If I have missed anything, please feel free to post the question again.
Otherwise, we've come to the end of this hour. And also, if you would come up with any more questions or would like to discuss with either Lisa or myself, we are available for those questions via email, and our contact details you can easily find on the SCC website. And with that, Lisa, I think I will thank everyone for tuning in, and I hope to see you again. As I said, keep updated with our seminar series and developments there by signing up to either our newsletter or connecting on LinkedIn. And with that, I thank you again and hope you stay healthy. Thank you, everyone.